Hello and welcome to The Dialogue, the latest in the Control Risks webcast series that looks at corruption and corporate malfeasance issues right around the world. I am Richard Fenning, CEO of Control Risks, and today we are in Hong Kong. We are going to be discussing the complex issue of compliance investigations and how to avoid compliance issues becoming significant corporate crises. I'm joined for this edition of The Dialogue by two guests. First is Kelly Austin. Kelly is the partner in charge of the Hong Kong office of the US law firm Gibson, Dunn and Crutcher. Kelly has been here in Hong Kong since 2001, first as Compliance and Litigation Counsel for General Electric and more latterly with Gibson Dunn. During the course of her time in this part of the world, Kelly has advised numerous international corporations on all range of compliance issues. Alongside Kelly is my colleague Dane Chamorro. Dane has over 20 years' experience in Asia, first with the US government and more latterly with Control Risks, working for our firm in China, here in Hong Kong, and currently as head of our Singapore and Southeast Asia operation. I'm going to start off by asking a few questions myself, and most of these questions are based on inquiries that we've had advance of the webcast from people who've signed up today. As we go on, if we have time, I will also ask some supplementary questions that will be handed to me during the course of the dialogue. But I'm going to start with Dane. Dane, things have been changing in this part of the world recently that I think make it more likely that compliance issues have the potential to become significant corporate crises. Changes going on in China and in other parts of the region. Could you just place what we're going to discuss today in the context of a changing region?
Sure. You're absolutely right, Richard. And China is probably the best example of that. But as you say, it's not the only example. We've also had, similar issues in India and Indonesia. But I think the main thing that has changed is politics. And I think it proves the point that there is, in fact, political risk in China, which is a fairly stable system. It's just a different type of political risk. But as you know, there's a new government, there's a new party leadership. That's really true in the last 12 to 18 months. Part of their platform, if you will, is a crackdown on what they see as anti-competitive and sometimes corrupt behavior by multinationals in China. And so this is a part of their political platform. They're driving it very strongly. And so that is one of the major things that we see multinationals grappling with in China is really an understanding of the political context and how maybe for the first time in a long time that's become absolutely critical to the success of their business and their business models. And that's just reinforced by the fact that China is now such an important market for almost every multinational that I can think of. It's the second largest economy in the world. And a lot of them, tie their fortunes on a quarterly basis to what happens in China and what are the growth prospects for China. So increasingly, if you have a crisis in China, it's not going to be something that you can deal with quietly in a corner and make it go away. It's going to be front page news. And so I would say those two things are really the two things that have changed in China specifically.
That's very clear. Thank you, Dane. Kelly, you've had experience on both sides of the fence as in-house counsel here in Hong Kong with General Electric and more latterly as outside counsel to a whole range of multinational investors. You see people arriving here for the first time or encountering these problems for the first time. What should they have in place before they encounter these kinds of problems? What are the kind of basics of preparation that people should have in mind?
Well, most multinationals, as Dane notes, have a significant presence in the region. So they've in most cases been doing business on some scale, particularly in China, but for most across Southeast Asia and across India as well. All three are significant markets, and when you look at growth opportunities for multinationals, particularly the emerging markets of Asia, significant driver of growth. Yeah. So I think businesses have a general sense. They may have a scale which varies significantly depending on the type of business and the length of time that they've been in Asia and how important Asia is depending on their particular industry sector or focus. But what they often have not thought of and haven't put in place is a plan for how you're going to handle the myriad of compliance issues that come up on a routine basis. Starting with a risk assessment of what those issues might be, but then when an issue actually gets raised, having in place a plan for addressing that, having the experienced advisors on call that you need to deal with the particular issue in the particular country and then in the particular city where that issue might come up, making sure that you have a plan for addressing the concerns that do get raised or the investigations that begin, and thinking it through not just from an internal perspective, but then also very much thinking externally. If a matter begins as a small internal investigation, in today's world, as Dane said, very complicated from a political perspective, also very complicated in terms of the way in which information flows in the market. Very public, very instantaneous, heavy reliance on the blog sphere, on local press in certain markets like India and Indonesia, where there's a tremendous amount of local press attention. When you have a crisis, things tend to move very quickly. So the companies that do it well are the ones that understand their markets, understand their go-to-market strategy in those markets, have in place the resources either internally or externally, and in an ideal situation, both, to deal with a crisis, and to be proactive about trying to suss out when there's a potential for a risk, and then when there is a risk, to be almost instantaneous in how they deal with it.
That's very interesting. So 2 points I'm taking for that. One is that we shouldn't look at these markets, whether it's China, India, Indonesia, or elsewhere. We should not look at them as being homogenous. It's enormous varieties within the country itself. And secondly, that the use of new media is now a key factor in what turns what may in a previous era have been a minor irritant into potentially a much bigger kind of corporate event.
Absolutely. Well, and the other thing that I would say is that, as Dane noted, there's a tremendous amount of political attention to corruption issues across the region. In many countries, India is perhaps the best example in Asia, that political attention to corruption and the enforcement action that is flowing from that is in large measure being driven by public attention to corruption issues. So the Anna Hazare movement in India and the legislative changes and the enforcement actions that have come as a result of the public attention to corruption issues are very much linked. One really drives the other.
Right. Yours is the India example is a bottom-up, and the China one is a top-down approach. But you're absolutely right; it's a hot-button issue. Yeah. Right. Yeah.
So what's clear is that these changes are kind of here to stay. This is not a flash in the pan. These are profound market changes that we've all got to get used to. But Dane, if you're sitting outside of the region and you maybe in the US or in Europe potentially or elsewhere, and you get news of some kind of trouble, for instance, at your China subsidiary, what are those first key steps that you need to take?
Yeah, I mean, Kelly already touched on a couple of them, having the investigation protocol, having the crisis management protocol, ensuring that you know where your data is mapped. Ideally you're familiar, if it's China, with the state secrets law and what might be exported, may be exported legally and what may not be. Having the advisors identified, and having that knowing your regulators, I think is critically important in all of these markets, and it's something that I think is sometimes overlooked. That it's really important that you know, if you're in China, if you can know the local deputy party secretary, the deputy mayor, the head of the PSB. You should know all those people because that can be helpful later on, and that's not just unique to China. That's true in Indonesia and India, probably even more so. Right. So you need to have all of those, and I think you do have to have an understanding of, as Kelly said, the new media environment. And I think sometimes the perspective from headquarters is that these markets are not particularly sophisticated. And I think that's a huge potential trap to fall into, because particularly from a new media perspective, they're incredibly sophisticated. Even Indonesia, which is in many ways the classic developing market, but it's the largest, the largest usage of Twitter and Facebook outside of North America. So that tiny problem that can surface in a new media environment suddenly becomes blown up and becomes a huge issue for you to manage reputationally, perhaps legally, at headquarters level, perhaps because you've overlooked one of these critical elements. So I think that kind of local understanding of how the enforcement authorities work, but also the new media environment, I think that is sometimes missing, and people are very much kind of their focus is what do our home country regulators, enforcement authorities, what are their top priorities, how do we operate with them, and they've kind of forgotten about the fact that there are local enforcement authorities, whether it's India, Indonesia, China, wherever it may be, that are critically important to your business in that jurisdiction. Yeah,
I guess it's the perennial risk that people tend to judge markets always through the kind of prism of their home market, the market they're familiar in. Yeah. Kelly, you've worked for a whole range of companies, and I guess you've seen some handle these issues well, and I imagine you've seen some falter at the first step and make all kinds of mistakes that they then have to try and fix later on. What are some of the common issues, though, some of the common mishandling issues that people get themselves caught up with at the outset of these sorts of problems?
I'd say several things. One is not taking seriously enough concerns that are raised, particularly through new media or through an anonymous source. When we look at the investigations that we conduct across the region, an increasing percentage of them are concerns that are raised by anonymous sources, often through anonymous email. That's particularly true in India, and it's particularly true in China.
They may come through the whistleblowing process that people have in place, potentially?
May come in through the whistleblowing process, particularly if you have a concern escalation process that is robust and robustly communicated. Employees and external parties may choose to use those channels to raise a concern, but what we often see are anonymous emails that come into a single individual, and what is essential is that everyone across the company needs to understand, first of all, that every concern that is raised needs to be taken seriously. Just because it's anonymous, just because it doesn't have a significant amount of detail that comes with it, doesn't mean that there's not a valid concern that's being expressed.
I think, just to add to that, I think the thing that we see a lot is what I call the knee-jerk, and that can go one of two ways. A common one is, well, this is completely unfounded and our employees, of course, are innocent, which is often not the case, particularly, I would say, in a system like China. If the authorities are coming after you, they've probably done their homework, and there's probably a good reason for them to devote those resources to it. The flip side of that is kind of instant dismissal. And that can be incredibly problematic because you may not be able then to retrieve some of the information that's critical to understanding exactly what happened and who is connected to whom. And we just had a case of that actually in Vietnam. And it's absolutely critical to know before you take an action like that, the so-called identified party, who they're connected to, what the scheme was, if there was a scheme there, that type of thing, before you take an action like that. So that's what I call the knee-jerk. It can go one of two ways, and usually both can be much more problematic to unwind down the road if you don't actually know what's behind it.
And I guess there's a tendency, probably everywhere in the world, but this area would be no exception, is to suppress bad news. So nobody wants to feed up the food chain back to headquarters that they've got a problem.
Yeah. Correct. Particularly if the concerns are coming into a business manager, that may very well be the case. Yeah. Or they may be, as Dane said, too quick to either bless or dismiss the concern that's been raised.
And I think that's particularly true in these markets that are big and growing very quickly. They're often looked to as the P&L savior for the next quarter. Yes. And if you have a problem as a manager, you probably can figure that that's not great for my promotion prospects, right? So I think there is this greater desire to kind of, let's deal with it ourselves. And then, of course, it also has the potential to blow up into a much bigger thing.
Right, storing up trouble for later.
Yeah. Well, and Richard, one more point, if I may. You sort of asked what people don't do well. The other thing that I think people don't do well is they don't have the proper appreciation of the very local issues that they're dealing with. And that often comes because you'll have, particularly if you have an investigation matter, investigation resources, to the extent that they exist in a corporate, in a multinational or other corporate entity, they tend to exist at headquarters, and sometimes on a regional basis, but they are rarely local.
Yeah.
And so what often happens is you have individuals who may have a tremendous amount of experience in a particular market in Asia, or may have none, sort of vaulting in to try to deal with what is often a quickly escalating risk and a quickly escalating internal investigation, which may in fact be internal and external. And if they haven't done their homework, and if they don't know sort of who the resources are locally, internally that they can draw on, and if they don't have trusted advisors that really know at a granular level both the particular market and the particular risk area. So if you do corruption investigations, you should have people who do corruption investigations. And then also don't have on call the proper local expertise. To the extent that they don't have the expertise internally, they need to have trusted local advisors that they can call on who really do deal with these issues day in, day out.
And I guess that also speaks to your point earlier about this being very granular and very local. So this is not a all of China plan or an all of India plan. What you may have in place in your headquarters office in Shanghai or in Mumbai or Jakarta, you also need to have something in place for the sort of remote operations you have in different parts of the country. So I guess sometimes it's junior employees who are the first recipients, the first people who realize that something is going wrong, that an investigation is underway.
Particularly in terms of an external enforcement authority, their first point of contact is often the office receptionist in a local sales operation or in a local manufacturing operation.
Yeah, and I think that's one thing that we see when we're dealing with the crisis management issue, is that sometimes the national leadership will have been trained, but as you say, that first point of call, the receptionist or the local junior staff won't have been trained, and they won't have anything to do, they won't have any idea what the response should be. And then quite often, as a result of that, the authorities are able to come in a very aggressive way, and it's not escalated in a proper fashion, et cetera. So, that's absolutely.
But you also made the point, Richard, which I think is a good point to follow up on. These matters are very granular, but they're also very global. So often when we're doing an internal investigation, or when we're helping a client to manage through a government investigation, we're playing multi-dimensional chess, if you will. We are looking at potential jurisdiction by a host of regulatory agencies and expectations and demands from a host of regulators in how we're conducting the investigation in a market like China. So we're looking local. How are we going to address this particular issue and understand it from both a factual and a legal perspective? But we're also constantly thinking, okay, and if this is, for example, a corruption issue, is the FCPA implicated? And if so, what do the U.S. Department of Justice and U.S. SEC think? And how are we going to analyze both the legal issues and the investigation in that context? And then often we're looking at, if it's a corporation that happens to be headquartered someplace outside the United States, what the home country jurisdiction is. And then depending on the individual employees that are involved, we may also be considering local individual culpability under their home country, if they're a passport holder in Australia, for example, or if they're a passport holder in the UK. So we're thinking through on a multi-dimensional basis an issue that is very local.
So there's a complex matrix that people have got to figure out, not just what is happening in the country where the incident is taking place, but this multitude of jurisdictions that may be invoked, I guess, as the investigation gets bigger. I imagine also people have got to get their minds around the fact that the role of the attorney is different. For instance, if the investigation is being carried on in China by the authorities, what they might expect their external counsel to do is going to be different to what they would expect it in the similar sort of incident in the United States.
Or what their external counsel is going to be permitted to
do, rather, yeah.
To be more accurate. So there, in a number of the jurisdictions across Asia, there is very limited recognition of legal professional privilege. In China, essentially none. And just to continue with China as an example, in a government enforcement action, little formal role permitted by the government authorities for both outside counsel and in-house counsel to participate in the kind of enforcement activities that are customary, questioning of witnesses, seizure of documents and data. So if you're thinking about it from a European or a US perspective, and you have a sense of the role of legal counsel in being able to manage interactions with government authorities, you need to think about it from an entirely different perspective if you're talking about a China investigation.
Right. You mentioned data there, and it brings me on to a question that's been submitted from a US-based bank. I think it's a global bank, but based in the United States. And this is a question from an officer in their financial crimes division. And it essentially is about data and what is the restrictions that surround taking data. I think there's specifically regard to China here. Taking data out of China, presumably in the course of an investigation, there'll be a desire to take that data back to the United States. It's not that easy, right?
It's not that easy. It's quite complicated, and again, it is both granular and global, so local and global. You need to very much understand the local requirements, the particular concerns in China surrounding state secrets being the most evident area that you need to understand. But frankly, there are data privacy regimes across all of Asia in individual countries that make it complicated to both collect and then export data. And so your plan, your investigation plan, which Dane and I have mentioned previously, needs to take into account both the mapping of your data, where are your servers, and then an understanding of if you have an investigation in China, for example, or in Korea, another jurisdiction where there are very significant data privacy restrictions on both the collection and export of data, how are you going to run an investigation, and how are you going to collect and review data?
And I think one of the differentiating points there between, let's say, a developed market like Korea, Singapore, Hong Kong, is the motivation behind the laws. So in those jurisdictions, it's very similar to the EU, which is it's motivated by privacy of the individual. In China, the state secrets law is about the power of the state. And so the motivation is different. And the law is written in such a way, not to make a legal comment in Kelly's place, but that essentially a state secret can be anything they want it to be. And so you might be in what you think is a fairly mundane industry, but one of your clients, suppliers, may be state-owned. In China, that's almost inescapable at some point.
Sure.
And they can deem information related to that counterparty to be a state secret because it's owned by the state. So you don't have to be in the defense industry, the telecoms industry, to be subject to that law. I think that's important to understand, and they enforce it pretty strictly.
Mm.
And so from a data forensics perspective, when you look at China in particular, that's why firms like Control Risks have built an entire infrastructure to allow the collection and the searching of data in China,
sure, yeah.
So that we are not faced with the difficult export issues. You can export data, and there are ways to do it, but you need to be careful. And again, what that means is you need to have expert advisors who can help you through those issues.
Sure. I've got another question here that's come in from the general counsel of a manufacturing company based here in Hong Kong, actually. And the question relates to the specific differences between managing a crisis in China compared to India and indeed to Indonesia. So obviously it's a very big question, but Dane, some thoughts on what distinguishes those three key markets. Those are the markets that keep coming up in our conversation, and I think we collectively know that these are the three markets that are very often at the front of mind of our clients.
Yeah, I mean, I think if you're talking about particularly managing a crisis from an enforcement perspective, an authority investigation or enforcement, in China, for good and bad, you are dealing with a Leninist system, and that's a system that's fairly used to doing wide trawls of information and people, in some cases, and data, and processing through that in a way to meet their goal. And so, relatively speaking, although there are different enforcement authorities, as we talked about earlier, police, SAIC, et cetera, you are dealing with a fairly coherent structure and system. The challenge to it is that it doesn't interact with you. So again, because of the Leninist nature, they sweep all of this data and the employees, et cetera, up if it's a case like that, an investigation. And then most companies are used to developed markets where you then have a sort of dialogue, for lack of a better word, with the authority to understand what the goal is and how you can assist. And in China, that's completely different. That simply doesn't exist. There is no dialogue. It's not possible. So frequently we see these companies that they're really operating in a real information vacuum because they don't get anything back even if they ask. Where are my employees? What data has been retained? Why? When are we going to get it back? Nothing. You get nothing back. So that can be quite distressing, not just for the corporation, but also, of course, if there are employees involved, the families of the employees, who, of course, will be looking to the corporation for assistance and guidance. I would say in a place like Indonesia or India, for lack of a better word, it's a bit more informal. And I would say where you need those relationships, obviously you should have relationships with your authorities, your regulators everywhere, but in markets like that it's particularly important because even if you have a relationship with an enforcement authority, let's say in China, if you become the focus of investigation, you will not be able, for the most part, to utilize that relationship. But in India and Indonesia, you can. And that's critically important to know who's involved, because there are often a number of parties involved. So in Indonesia, I can think of 3 off the top of my head that might be involved: Ministry of Justice, Police, KPK, which is the anti-corruption authority. And often they have very competing agendas and not particularly well aligned with each other. So in those types of situations, it is, in a way, you're juggling more balls, and it's critical that you have those relationships so that you can go to people informally and say, can you help us understand where this is going, as compared to China.
Well, and the one thing that I would say also, just to note, again, we keep talking about new media and the press, particularly in India, the risk that a government investigation will become the subject of media scrutiny is increasingly substantial. And when that happens, that injects an element of uncertainty into a particular proceeding. And so it may, if it becomes public, both create a reputational crisis that you're having to deal with, but also have an impact from a legal and enforcement perspective on the matter that's underway.
Yeah, I mean, that's a very good point, since the media is most of the traditional media in China is state-controlled, but Indonesia and India are big, messy, multi-party democracies. That sometimes becomes the tail wagging the dog. I think that's fair to say. Yeah.
So let's just sort of fast forward, and our fictitious client has been through some compliance problem. It's spun out of control. It's spun beyond the boundaries of the country, whether it's China or Indonesia or India or wherever. They get some sort of resolution through the legal process. I guess there's always a temptation for people to kind of close down their efforts and try and get business back to normal. But I guess there's a phase there, Kelly, where people have to draw lessons from what they've just been through, however reluctant they may be to sort of wallow in the mire. But nevertheless, there's a period of time where people can take some of the lessons of what they've been through and really apply them to make their businesses stronger for the future.
That's absolutely right. Even in the strongest multinationals, there are always lessons learned, even if it's an internal investigation, and it's not something that explodes into a government enforcement action or to a crisis. We are always very focused in every matter that we work on the corrective and remedial action plan. We care about it because you want to make sure that you don't repeat these lessons time and time again. You want to make sure if you've addressed an issue in one office, that you've assured yourself that you don't have similar misconduct, similar process control breakdowns, similar policy weaknesses in other parts of your operation. And you want to make sure that, particularly if you haven't had a government enforcement action, that you have buttoned down your investigation and the response to your investigation so that if that matter ever becomes known to the authorities, you're in a position to tell a very compelling story about both the robustness of the steps you took to investigate the matter when it was raised to your attention, but also the completeness of the steps that you took to address and remediate any control breakdowns or policy weaknesses or potential legal or regulatory issues that emerged. So those two have got to go hand in hand. It should go from a commercial and reputational perspective. It should be part of what you were thinking, but also from a legal perspective, it's essential to have the two halves form a whole.
Yeah, and I think there's managing a crisis and then there's managing through the crisis. And so I think part of it has to be, actually, even when you're dealing with a crisis, is where do we want to be 3 years, 5 years down the line? Yes, we have to deal with this. We have to run our business concurrently. But where do we want? What kind of company do we want to be? What kind of reputation do we want to have in this market? What type of relationship do we want to have with our stakeholders, the public, our regulators, 3 to 5 years from now? And ideally, you have a goal that's that sets you ahead of where you are at that time. So I think that's absolutely important, is that you think beyond the immediate crisis to the future.
Yeah. Well, and if you address the immediate crisis, I think perhaps you don't get the eventual massive crisis, right? That's the other point.
Hopefully, yeah.
I think for many of the people who are watching today, they will have to deal with a series of smaller matters. Hopefully they'll never have a massive matter. They'll have to deal with a series of smaller matters, all of which can potentially be complicated and time-consuming. But hopefully if you manage smaller matters well and you take the lessons learned from them and you apply them across your business, you never have the massive matter.
Right. And I think that's a good point, taking the lessons learned, because it is often, as you said earlier, something that people try and once it's resolved, you want to forget about it and put it in that dark toolbox somewhere. But as a result, then there's no cross-learning across the organization, even within one country. So the lessons can be, in a sense, wasted. Yeah. Whereas if you actually say, look, this is the problem that we went through, this was the issue, this is how we dealt with it, this is what we could have done better, then you spread that learning across the organization. And I think you do then, you essentially create capacity within the organization to deal with those types of issues, whereas if you put it away somewhere, then nobody knows.
Yeah. And it's always easier to push change or radical change for an organization in the wake of some kind of significant problem. I think we've all seen that. Yeah. We've been talking about these, as you mentioned at the beginning of the broadcast. We've been talking about these extremely exciting markets, Kelly, like China and Indonesia and India, and inevitably our conversation has somewhat dwelt on the difficulties of doing business here. But I'm assuming that none of this should put people off from coming to do business here, that whilst corruption may be significantly further up the risk agenda, the opportunities that these markets present to our clients still massively outweigh some of the pitfalls that we've been describing.
Well, the risks in any emerging market exist. So we're talking about things that are potentially unique about individual markets in Asia. But if you look at the risk profile generally, and we're obviously focused today on corruption and corporate malfeasance, that risk exists globally.
Right.
And the challenges of both understanding a market and figuring out how to do business effectively and with integrity in a market, that again is a global challenge. And the other thing that I would say is, particularly in the anti-corruption arena, that the standards that apply to doing business are increasingly common. So when you look at the laws and regulations that apply to your business conduct around the world, they're frankly just the same or almost the same in markets like India, Indonesia, Vietnam, China, as they would be in various European jurisdictions or in the United States. And we're moving to a sort of level playing field from a regulatory environment. Those regulations may not be consistently enforced in each of the markets that we talked about, but in terms of the standards, very much moving towards consistency, which I think makes it helpful for multinationals who, as you say, see significant opportunity in the markets in Asia, should see significant opportunity in the markets in Asia, and also are running truly global operations. Many multinationals are doing business in well over 100 countries, and the risk profile for any particular country is significant in terms of the way you do business and the controls you put in place, but you don't pass on most markets simply because there's risk there. There's risk everywhere.
Yeah.
Right.
Yeah, I think that most of these markets, the one we've been talking about, certainly they're too big and they're growing too quickly to be ignored. It's almost a non-optional, right? You have to be there in some way. And I think an example, a specific example to what you mentioned, Kelly, is we get, and I know you get a lot of questions about facilitation payments, and you often have a client or a company saying, well, we don't under the FCPA, that's okay, and the thing that we usually raise is, well, but under local law, it's not okay. I don't know of a country that says, yes, you can pay small amounts of money to local officials, but you can't pay large amounts of money. That doesn't exist, right? The other thing, I think, to your first point is, you can do risk assessments of these markets, and of these jurisdictions. And you can do it on a holistic basis. So what are the regulatory and environmental and community and political and all the other risks that we might face, but also quite specifically, what are the corruption risks we might face? Where is the hand going to come out in the process of permitting or licensing or winning business or whatever it might be? So there's, in a way, that there are structures out there to help you enter these markets and still minimize the risk.
We've just got time, I think, for one final question. This one's actually come from within China itself, from a compliance manager with a global manufacturing company. And this is specifically about personal data and the treatment of personal data within an investigation in China, within an internal investigation in China. We've kind of touched on this before, and I think made the very good point that it's a complex web of different rules and regulations all over the world. But are there specific points that you might raise in relation to personal data in China?
I think the specific point is you need to make sure that you're minimizing the impact on personal data while you're collecting the information that you need to conduct a thorough investigation. And frankly, we do that whether it's China or other jurisdictions. You're looking for information that's relevant to your corporate investigation or the government investigative activity that you're responding to without being overly intrusive in terms of personal data. The thing that is unique about China, and again, Dane and I have mentioned it, is the state secrets law. And that should not be in a position where it implicates personal data, but there are situations where it can, because as Dane noted earlier, state secrets are so broadly defined, it could be an intersection between the newly emerging personal data privacy principles in China. Keep in mind also Hong Kong, where we're sitting today, has very different, highly developed personal data privacy ordinance, and then the intersection of the state secrets laws.
Yeah, I think, the personal privacy issue is evolving in some of the markets, and China is one of those. As Kelly says, I still think the state secrets law is probably the overriding concern. But I think you can't ignore the fact that the kind of malfeasance that we've been talking about, self-dealing, conflicts of interest, et cetera, are so common in an environment like that, that from a corporate perspective, there are certain things that you can do that would make it easier for you, such as consent waivers in an employment contract, where essentially any of the data that goes across the corporate devices is accessible, et cetera, that you really have to have that, even rules against bring your own device, right? So that if someone's communicating at work, they're doing it on a corporate device. Those types of things that the corporations absolutely should make sure that they have, in addition to all of the other compliance and training and other procedures to make sure that they're as protected as you can be. We're
increasingly struggling with the bring your own device issue, particularly with the prevalence of WeChat, Twitter, other QQ in China, other forms of instant messaging and quick communication. Those tend to happen outside the corporate channel on personal devices, and if the company doesn't own those devices, it can make it enormously difficult in an investigation.
Good. Well, thank you both very much. It's been a tour de force, actually, in taking us through some of the biggest and most complex markets in the world. One thing that I've been really has stood out for me in our conversation is a sense of optimism, actually, about these markets from both of you. That whilst the changes that are going on in China and India and Indonesia are absolutely kind of profound and link into the changes that are going on in these societies more generally, there is a clear sense that these markets that are already very exciting are potentially going to be stronger if and when we get to a position where these kind of regulations are imposed fairly and firmly right across the board. And it is something about these markets really becoming part of the kind of global economic community and not just issues that are very, very specific to each country. But thank you both very much. Thank you, Kelly. Thank you, Dane. And that brings us to the end of this edition of The Dialogue, brought to you today from Hong Kong. Thank you very much for tuning in, and look forward to you joining us for the next edition. Thank you very much.